We will call the final case on the docket this morning, State v. Shannon Cavitt, 127479. Counsel, you may approach.
May it please the court, I'm Ryan Enninger, Assistant Appellate Defender, appearing on behalf of the appellant Shannon Cavitt. With the court's permission, I'd like to reserve 3 minutes of rebuttal time.
3 minutes to be granted. Thank you, Mr. Ed.
Thank you. A Sedgwick County jury in this case, after a lengthy trial, found Mr. Cavitt, my client, guilty of 1 count of felony murder, with the underlying predicate felony being aggravated robbery. He was convicted of, or acquitted of, a standalone charge of aggravated robbery. The jury also found him guilty of 4 counts of aggravated or kidnapping. And all of those instructed with the commission of flight or in the act of committing an aggravated robbery. Furthermore, the jury then also convicted him of I think it was a 4th count. There were 3 victims in one room, alleged victims in one room and another. So there were actually 4 kidnapping counts. What I'd like to start out with this morning, well, afternoon, I guess, is to address this first issue in our brief concerning the conviction for felony murder with the underlying predicate felony of aggravated robbery. What I've argued in this case is that this has to be a theory of prosecution based on aiding and abetting, because there was no direct evidence of my client, Mr. Cavitt, actually participating. He was never in the room that the victim was in. Mr. Dennis Haynes, who was shot in this case, he was never in that room. He was the only. All these are almost all of them, except for the kidnapping, were charged as aggravated crimes involving the use of a firearm. My client was the only one who didn't have a firearm. So I've wanted to establish that initially, to just say that the only way that this can be really assessed and analyzed is through the theory.
Why is that? Why isn't he just your client directly involved in the entire episode? Why is he an aider and abetter simply because he wasn't present in the room when he was actively involved in allowing everyone to enter, actively involved in the activities that occurred during the sequence of time that's relevant? Why is he just an aider and abetter?
I think he's just an aider and abetter because he is basically the facts and the evidence in the case are that we have late night meeting between the defendant, my client, who's allegedly present in this room, another individual, Conway, and another person, Robert White, who is referred to as Nice during this whole entire situation. The evidence was that all from Mr. Conway, who immediately after this, after he was arrested, within a couple of days, sought a favorable plea deal. So everything comes from Mr. Conway through that lens. Mr. Conway says that they're sitting in this apartment for, I think he said it was like 4 or 5 hours or something, from 1 or 2 o'clock in the morning till almost dawn. Mr. Conway says that he and he had gone to sell Nice some marijuana. When he arrives, Nice says, "You're going to help me commit a robbery." And Conway says, "No, I'm not." And so allegedly Conway then pulls out a weapon, points, or says, "Yeah, you're going to, or I'm going to shoot you. And if you don't think I'm going to shoot you, I will actually shoot you, and I'll kill your children and your wife as well." So the only evidence of what my client was doing at that point was that he was present in another room. Conway specifically says he's in another room. So all that Conway said then was that my client said, "Listen, I know this guy, Dennis, who has drugs and doesn't always have a gun." So then that's the only that's the evidence with his initial involvement in this whole thing. So it's very limited as far as what his involvement was, what it was supposed to be. Supposedly they're planning this thing for 4 or 5 hours, but Conway can't give any information, any sort of claims of what this actual plan was.
May I interrupt? I'd really like to, your issue 3, I think it's your issue 3, says that Williams' confinement was insufficient because it was merely incidental to the aggravated robbery. Now, in response to that, the state specifically asks us to overturn Bugs.
Right.
And I'd really like to get your opinion on that.
I don't think it's appropriate to overturn Bugs. I know that there's been some concern or some question about that case was directed towards a different standard of multiplicity. Yeah.
Right.
So we had a different standard of multiplicity at the time, pre-Schoonover, pre the identical elements test. I think that, and I know this court has sort of stated that this idea that, okay, just because every time we have let's say a rape, like it was in Bugs, I believe, or in this case, a robbery, you're going to have just sort of a tack on kidnapping case. So, and I know the court said it's not this court's business to worry about policy on that respect, that's the legislature's role. What I would argue is that especially in a case like this, you can see that the way, even though the elements aren't exactly the same, in this case, they're really, really close. So you have an aggravated kidnapping that's based on, so you have a robbery and a burglary. The burglary is dependent on a robbery. So it's charged, he entered with the intent to commit a felony, being robbery. So it's very hard to sort of pull these two offenses apart.
Why is that? I was either under Bugs or the couch dissent. Why isn't there sufficient evidence to support kidnapping? The evidence showed that one of the defendants put his hand over the victim's mouth, and then the other held a gun to her head. She's pregnant, and thereby defeating her any ability to move and warn anybody else that's in the house. Why isn't that under any theory kidnapping? I don't see where Bugs comes into play here with the concerns that were addressed by the dissent in couch.
The question,
help me with that.
Okay. The question of whether Bugs is still something the court wants to retain aside, I think in that specific question, I mean, relying on Bugs, on that precedent, on this court's precedent, that movement was very slight. It's incidental to the crime of aggravated robbery. And that's essentially what we're faced with, is this situation of every time that, I mean, a robbery is going to be almost always a situation where somebody's
robbery. She was in bed and was in the residence and was prevented from moving or warning or doing anything as a result of the three defendants' activities. I guess I don't see where this is one of these situations where there's an aggravated robbery incidental to that crime. Seems separate from that in this for Ms. Williams.
You're saying that, well, I guess my response then is Ms. Williams is in bed with the victim who is the intended target of the robbery, and they're surrounded by cash and narcotics. So I think the robbery is, or the kidnapping is incidental to the robbery, because they're not there to just kidnap people. There's no plan or no sort of overarching thing of, hey, let's go kidnap some people. Like, we're going to kidnap these people for some other purpose. The purpose was very expressly, according to the way they're charged and the way the state argued this case and presented its case, that they're there to commit a robbery. And my client was there my client is if anything, he's aiding and abetting. And I've argued that this evidence isn't even sufficient to support that. What I would also point the court out to, and what I rely on in this sufficiency claim, are things like, okay, so you have the definition of aiding and abetting, and that to be guilty of that, you have to knowingly and willfully associate with the unlawful venture and willfully participate, and as if you wanted to succeed. So if we look at the facts of this case, we have first, so supposedly my client's supposed to show up and let these guys in. That's the whole plan that they took 4 hours supposedly to come up with. Second of all, you get to the first time they get to the apartment where my client's supposed to go in and facilitate this whole thing, right? Play his role. He goes in, does nothing. He doesn't give them the signal, hey, come on in, everything's clear. He just comes back out, and then he leaves. And then so they're like, what are you doing? No real explanation of that from anyone. So then they come back another time, a second time. This time, my client's supposed to do the same thing. So on this occasion, the other two defendants, they're more far removed from where or a little closer, I think, to where the defendant is parked in his car. They're waiting for him to go in and supposedly effectuate his role in this offense. He's asleep. They come back and they say, what is he doing? They send, Conway, not nice, says, I went back up to the car, like, what's going on? I look in, and the state has sort of said that he was maybe sleeping. The state also said that they thought he was just psyching himself up. Conway clearly says he's asleep. So if he's supposed to be effectuating this role in this crime, why is he sleeping? What is he doing? So then he goes, from that point, he says that Nice then comes over. Both these people are armed, have firearms. My client's the only one that does not. So he leans into him with both of them are armed, and Conway says that Nice told him to get up and move and go do your thing. So it's more of a command at that point than a willing. I think there's evidence that this wasn't a fully willful and voluntary act on the part of my client. So, and that's where I come down on this question of aiding and abetting.
Do you have any cases that support that position? I tried to look for some. I couldn't find. And
I should have probably.
We even have cases where a co-defendant wasn't even present at the time of the murder and still be held responsible and convicted of felony murder. What's the difference?
I understand that could be a potential situation. At the same time, I think that in this particular case, it would fit with a line of cases or an analysis where there's some evidence of a disengagement. And the re-engagement, I have tried to argue here in the brief, and I'm arguing for the court, the re-engagement was then prompted by somebody who's armed with a gun and is told, I want to go in this house. Lastly, there's this sort of idea that my client was supposed to allow access into the home somehow. Because Conway says, well, we don't know who this guy was. My client supposedly provided this information. But when Conway and Nice are in the bedroom and Nice has a gun pulled on Mr. Haynes says, I know who you are in the mask. So there's definitely evidence here that these guys weren't relying on my client for this information, for this whole situation to go down.
The video indicates that isn't the case.
I'm sorry?
The video doesn't indicate that position in terms of the just of your client not only facilitating the entry and then going in.
Right. I mean, it does show he knocks, somebody comes to the door. There's no audio, so we don't really know exactly what you said. But I've also argued under the burglary in this case, so I've tried to cover that aspect of the case as well, is that there was no evidence that he didn't have wasn't granted permission. That came back from a jury as a question. What does it mean to have authority? And the court said it means permission. So to me, he's already been in the house. All the evidence is he's been in and out of that house pretty much all night. And that's what was happening in this home is he's coming, he's going. He comes to the door, he knocks, and you can't tell exactly, but it would seem to be that this person that answered the door would have said, come in, because he's been there 3-4 times before. They know this, they know him. So that would be my response to that question. Unless the court has any further questions for me, I would yield the rest of, well, I am out of time. Thank you.
Any questions? Thank you. Mr. Maloney, and thank you for filling in too.
Thank you, Your Honor. May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I'll plan to address issues 1 and 3 from the lectern today, since those were the topics that counsel argued today. Starting with issue 1, I think there really are 2 separate arguments that the state's making in this case. One being a legal argument in response to the argument that the defendant raised in his brief, and then secondly, a factual argument. From the legal perspective, I think that there are essentially 3 well-established legal principles or theories that this court has set forth for a number of years, decades in some cases, that refute the defendant's legal claim that because this was an aiding, or theoretically in his view, that this was solely an aiding abetting case, that this demands a different result because he was acquitted of the underlying felony. Those three legal theories are, first of all, this court has made very clear that aiding and abetting is no different than principal liability when you're looking at it from a criminal liability perspective. There simply is no distinction in the law of whether somebody, depending on whether somebody is convicted under principal or aiding and abetting theory. Secondly, as I said, this court has indicated that you do not have to be convicted or even charged with, for that matter, the underlying felony in order for a felony murder conviction to stand. This court talked about the fact that, and that dovetails with my third point, which is that inconsistent verdicts are legally acceptable. And this court has indicated that we don't have any idea. There are a myriad of reasons why a jury might reach an inconsistent or seemingly inconsistent verdict. It could be jury nullification. It could be a jury compromise. It could be jury confusion. It could be a mistake. We don't know, but those verdicts are nevertheless allowed to stand. So when
You
you
would agree, I'm just looking at the verdict form. I'm looking at it right now. It's a strange, how the jury determined this case is odd. They found Mr. Cavitt guilty of on the felony murder under aggravated robbery, but acquitted of aggravated robbery on the separate charge, and then not guilty of felony murder, aggravated burglary, but guilty of aggravated burglary. It's just,
yeah, it's definitely strange.
It's confounding.
When I picked up this brief for the first time on Friday, I will admit that when I first read through that portion of it, I went back and read it again to make sure that my eyes were not playing tricks on me, because it definitely would have been much more logical for the jury to acquit of or to convict of the robbery and not the burglary. So it is unusual, but again, that does not defeat the felony murder conviction under all of those theories that I just articulated.
Did you notice that instruction 8 and instruction 9 are written differently?
Let's see if that is cited in the brief.
The committing, or in instruction 8, it says was committing to attempting to commit aggravated robbery, and then in instruction 9, it was committing or attempting. I mean, I think it's or, but I was just looking at that, and it was, to me, I don't understand. I don't understand. Trying to figure out whether this makes a difference or not.
Right.
The crime of conviction is out of instruction 8, count 1. So we've got committing or attempting. So it's possible the jury just looked at the attempting aspect of this, so we called it good. It's just, I got hung up on the word to.
Right, yeah, and that could
make of it.
Yeah, that could be, maybe that did cause some confusion. One thought I had, again, just from reading the briefs, who knows, maybe they thought that because the defendant himself did not apparently come away with any of the proceeds from the robbery, maybe that was why they might have acquitted of the robbery itself, but then found that it was in the attempt to commit a robbery and that was therefore sufficient to support the felony murder. But I think the fact that there are so many possibilities here just illustrates why this court has told us that we really can't go beyond the verdict and try to guess at those types of things. And that as long as we can show that there was sufficient evidence for the felony murder, that conviction should be affirmed. So those would be my legal arguments with respect to the defendant's underlying premise. Turning to the factual, I agree with, I believe it was Justice Rosen pointed this out, that this is not something where the state solely prosecuted him as an aider and abetter. Mr. Gillette cited in the brief some of the arguments that the prosecutor made in closing about how The defendant essentially was the Trojan horse in this case, and he, in the brief, referred to him kind of as the linchpin behind this whole plan because he was the one who knew the defendant and apparently had some knowledge about what the defendant did or did not have in the apartment. And so clearly, this was not something where he was just there. He was an active participant in this. And the fact that he might not have been the trigger man or even in the bedroom doesn't mean that he was not an active participant in the underlying crimes. So I very much do believe, as Mr. Gillette argued, that this was something where the state was proceeding under both theories, and there was evidence to show that he was not just an aider and abetter. He was actively involved from the planning, which, if there was anybody who was a reluctant participant, it would seem to be Conway, who initially flat out said that he wasn't going to take part in it until Nice threatened him with a gun and said that he would shoot him and his family. But the defendant was on board with the planning from the beginning, before they even got to the house or the apartment. And then once he was there and once they were inside, he took actions. He wasn't simply standing there and letting the other two guys do all the work. He did. As soon as he got in the house, apparently he was involved in actively restraining or putting one of the people up against the wall. There was some indication he did something else in the living room. And then while the other two guys were in the bedroom, he was essentially guarding. There was evidence to indicate that he was guarding, if not physically keeping the door closed, to make sure that those other three kidnapping victims could not get out and either escape or assist the victim and Miss Williams. So this was not something where he simply was a passive participant in this. He doesn't have to have been the shooter to have been a principal in these crimes. So that, from a factual basis, would defeat his argument that he was solely acting as an aider and abetter, and that somehow means that this conviction can't be supported. Turning to issue 3, which is the Buggs kidnapping issue, I agree with Chief Justice Rosen that in this case, even under the Buggs theory, under the Buggs case law, there would still be sufficient evidence to show that this was not simply inconsequential or slight for the reasons that you articulated. First of all, she was not the intended victim of the robbery. So to indicate that any restraint of her or confinement of her was somehow incidental to a robbery of a different person is not accurate to say. And they did. They covered her mouth and they held her at gunpoint. And I think obviously by doing that, you're making the completion of the robbery, the intended crime, significantly easier. Obviously, if she's able to escape and or warn Dennis Haynes, or perhaps try to find a weapon of her own to try and fight these guys off, clearly that crime becomes much more difficult. And so our position is that, yes, even under Buggs, this conviction would survive. But we do feel like this case presents an opportunity for this court to reconsider, and we would ask overrule Buggs.
But one of the hang up I've got on that, if we don't have to do it, is that one of the arguments against Buggs is the multiplicity concern. And you don't have that in this case. So, kind of why go out of your way to overrule Buggs when one of the justifications for Buggs is this multiplicity concern that doesn't exist in this case?
If you could explain a little bit more about why the multiplicity doesn't.
Well, you make the point in your brief that there's no multiplicity concern arising from the crimes charged because each contains different elements.
But I think that's the entire purpose, is to say that that's why this Buggs case should be overturned, is because it was the whole reason we have Buggs is because there was this concern under the old test that if the facts indicate that there were, just looking at it on a fact basis, that it would create multiplicity problems. But now, I think in almost every case, you're not going to have that multiplicity concern. If you're charging two separate crimes, there's no other crime that I'm aware of that has identical elements to kidnapping. So there's always going to be an elemental distinction between kidnapping and whatever the other crime is. So I think this case presents the same that any other case would. So if you're waiting for a situation where there would be a multiplicity problem, I don't think you'd ever be able to overturn Buggs, because under the Schoonover test, there's now always going to be that distinction of elements. So I think it simply is a matter of, we cited Couch in the brief, and I would simply reiterate what Justice Stegall and Justice Wilson wrote, or in that dissent, is that, again, Buggs was decided for this multiplicity concern that is no longer present. It did not go through any type of a plain language analysis of the statute. And then as to the stare decisis concern, I agree wholeheartedly, Justice Stegall, that it is a confusing test to apply. It was not particularly well thought out because it did not engage in that plain statutory language. And as you pointed out, I think there's little doubt that this court, or any of the Supreme Courts over the last number of years, would have analyzed very differently than what they did in Buggs. And so I think those are the conditions that make this very much ripe. And the fact that 2 justices of this court recently indicated a willingness and a desire to depart from Buggs. Of course, we've since had turnover on this court. And so I think these arguments with respect to Buggs keep coming up a lot. This was an issue that I've personally worked on a couple of times over the past couple of years. And so even though this particular case was not mine, it didn't take me that long to get up to speed, because I know I've been in this same position before. And so the issue does come up a lot in kidnapping cases. And so that's why I think it's important, one way or the other, for the court to tell us whether that is still, in fact, the state of the law, or if it should be abandoned, or at the very least adjusted. But again, our position is that even if this court declines to overturn Buggs in this case, that the evidence was sufficient even under that test for the reasons I've already articulated. If there are no other questions on those issues, I would again plan to just submit the remaining issues on the briefing that Mr. Gillette did, and we would respectfully request that all of the defendant's convictions be affirmed.
Questions, colleagues? Thank you, Mr. Mahoney.
Thank you, Chief Justice.
You're reserved 3 minutes.
May it please the court. I want to point out to the court, and this is volume 13, page 70. This is basically all the evidence we have in this case of what happened with my client's activities once he came into the house. So the video shows him go to the door, knock. He comes in, the co-defendant's behind him. Now, here's what Conway, who I would also say, real as a quick aside, to suggest that Conway was the only one that was maybe the least willing participant in this is just a bridge too far, I think, on just basic credibility level. The evidence is clear. Conway knew this guy. He was involved in interstate distribution of narcotics with Mr. Nice. Along with some other individual, Donald Jackson in Arizona. He also says later after this event that he was with Nice when Nice called Donald Jackson, and Donald Jackson asked him, "Did you kill the rat? Did you shoot the rat?" So they're very familiar with him, and it's just very convenient that he has this compulsion story. But with that being said, this is what we have. This is Conway's testimony at trial. He got, and I'm assuming this means Nice, because according to Conway, Nice is the one at doing, everybody else is doing the things that are getting him convicted. He got basically the defendant, my client, Wick is what his nickname was here, to, like, what am I trying to say, up against the wall, and was telling that dude, to be quiet. And then he had, and told me to grab his phone that was on the counter, and I grabbed his phone. Whose phone? I don't know. And neither does the jury. And after that, he grabs the other dude. Which dude? He pushes my client out of the way and grabs the other dude. So, and then he's seen the other two on the couch. So there's 3 people here or 4 people here. It is completely confusing and makes no sense at all. And after that, he says he had the other dude on the floor. and basically grabbed Wick, my client, because he was heavier than them and they're all skinny, and he forces him, basically has him lay on them and pushes them down. That's the entire really testimony of anything that my client did. And it looks like he's compelled to do this at all because he's grabbed by Conway and pushed onto these other people. Following this, he basically says at that point, I mean, Conway admits he's the one that goes to the bathroom. And I don't understand if the state's theory is that my client is holding this door shut on these three other kidnapping victims. How is he also rummaging through the house, as they said? So you can't have it both ways. He's either holding the door during this to facilitate the commission of these offenses by the co-defendants, or he's doing something else in the house. We don't know what. The only testimony was from one of the Mrs. Hayes, who's in the bathroom. She said when the door opened and they shoved the other two people in, who conveniently aren't here anywhere, Mr. Raphael, who was the one who opened the door from what the evidence says to my client, sort of just saunters off after the police show up and he's never heard from again. So there's another huge problem with that. And so I just don't think that there's sufficient evidence here to show that my client was actually willfully involved in the success of this outcome or the success of this venture inside that home that day. Unless the court has any other questions, we would just.
Any other questions? Thank you very much.
Thank you.
Thank you both for your arguments this morning. That will conclude this afternoon's docket. Court will be in recess until 9 a.m. tomorrow morning. Thank you.